I walked into the courtroom, my robe swishing around my ankles, and took my seat behind the bench. The air in the room was stale, recycled, much like the excuses I was about to hear. I adjusted my glasses, took a sip of water, and looked down at the docket. Case number 482, a dispute over a used car. Of course it was. It's always a used car, a security deposit, or a loan to a boyfriend who turned out to be a loser. Today, it was the car, a 2012 sedan that apparently decided to retire 20 minutes after money changed hands. I looked up. To my left, the plaintiff, a young man named Mr. Henderson. He looked nervous, clutching a folder of documents like it was a life preserver in the middle of the ocean. He was sweating. I don't mind sweat. Sweat usually means you respect the gravity of the situation. To my right, the defendant, Mr. Vance. He was leaning back, one hand in his pocket, looking around the ceiling tiles as if he were waiting for a bus. He had a smirk that said he thought he was the smartest person in the room. That was his first mistake. "Order in the court," Petrie said, his voice booming. "Thank you, Bird," I said. My eyes locked on Mr. Vance. "Mr. Vance, take your hand out of your pocket. You are in a court of law, not standing on a street corner waiting for a light to change. Stand up straight." Vance slowly removed his hand, the smirk fading just a fraction. "Good." I turned my attention to the plaintiff. "Mr. Henderson, you are suing Mr. Vance for $5,000, which is the maximum jurisdiction of this court. You claim he sold you a car that was, to use your words, a death trap. Is that correct?" "Yes, Your Honor," Henderson squeaked. He cleared his throat. "Yes, Judge. I bought the car 3 weeks ago." "And how much did you pay for this car?" $4,500. The extra $500 is for the tow truck and the mechanic's diagnostic fee." "Okay," I said, leaning forward. "Mr. Henderson, tell me about the day you bought the car. And be quick. I have a lunch reservation, and I don't like cold soup." Henderson shuffled his papers. I saw the ad online. It said the car was in pristine condition. It said runs like a dream. It said... "I don't care what you think it said," I interrupted. "Do you have the ad?" "Yes, Your Honor." "Bring it to me." Bird took the paper from Henderson and handed it up to me. I put on my reading glasses. I scanned the text. Typical sales puffery. 2012 sedan. Ice cold AC. New tires. Runs like a dream. No mechanical issues. Lady driven. I looked over the top of my glasses at Mr. Vance. "Mr. Vance, you wrote this ad?" "Yeah, I wrote it," Vance said. His voice was gravelly, defensive. "Lady driven," I read aloud. "Are you the lady?" There was a ripple of laughter in the gallery. I banged the gavel. "Quiet! Mr. Vance, I asked you a question. Are you the lady?" "No, Judge. It was my aunt's car. I was selling it for her." "Your aunt's car. Where is the title?" "I signed it over to him," Vance said, gesturing vaguely at Henderson. "I didn't ask you what you did with it. I asked whose name was on it." "Was it your aunt's name?" Vance shifted his weight. "Well, technically I bought it from my aunt, but I never registered it, so I just sold it to him. It's called flipping, Judge. Everyone does it." "Everyone does not do it," I snapped. "That is called curbstoning, and in many jurisdictions it is illegal to sell a car you do not hold the title for. But I'm not here to police your business practices. I'm here to determine if you defrauded this young man. You stated in this ad, no mechanical issues." "It ran fine when he test drove it," Vance blurted out. "I'm speaking." I raised my voice, cutting him off instantly. "When I am speaking, you are silent. Do you understand that? Good. You wrote no mechanical issues. That is a specific statement of fact. It is not an opinion. It is not, I think it runs well. It is a guarantee of the condition at the time of sale." I turned back to Henderson. "So, you saw the ad. You met Mr. Vance. Did you test drive the car?" "Yes, Judge. We drove it around the block. It seemed okay. The radio was on kind of loud, and he kept talking the whole time." "Ah," I said, "the old distract the buyer technique. Mr. Vance, were you nervous about him hearing the engine?" "No, I was just being friendly," Vance protested. I bet you were. Mr. Henderson, what happened next? I paid him the cash. He gave me the keys and the title. I started driving home. I live about 15 miles away. I got on the highway, and about 10 minutes in, the temperature gauge spiked. It went all the way to red. Then I saw smoke, white smoke, pouring out of the back. White smoke, I repeated. That's never good. That's usually water in the combustion chamber. Did you stop? I pulled over immediately. The car died on the side of the road. I tried to start it, but it just made this horrible clanking sound. I called Mr. Vance right away. And did Mr. Vance answer? No. I called 3 times. Then I texted him. No answer. I swiveled my chair to face Vance. He was looking at his fingernails. Mr. Vance, look at me. Why didn't you answer his calls? I was busy, Judge. I have a life. Once the money is in my hand, the deal is done. It's a used car. Things break. Things break, I mocked him. A car described as having no mechanical issues does not blow a head gasket 10 miles down the road unless it was already broken. You don't get to take $4,000 from someone, promise them a working vehicle, and then hide under your bed when it explodes 20 minutes later. I didn't hide. And look, I have a bill of sale. Vance reached into his jacket pocket and pulled out a crumpled piece of paper. He waved it in the air like a flag of surrender, though he clearly thought it was a victory banner. It says, "As is right here." He signed it. Bring it here, I ordered. Bird retrieved the crumpled paper. I flattened it out on my bench. It was handwritten on notebook paper. Sold 2012 sedan to Mr. Henderson for $4,500. As is, no refunds. I looked at Vance. You think this piece of paper is a magic shield, don't you? You think because you wrote as is, you can lie about the condition of the car? That's the law, Vance argued. As is means he takes the risk. Caveat emptor. Judge, buyer beware. I stared at him. The sheer audacity of the ignorant never ceases to amaze me. Mr. Vance, let me give you a short law lesson, free of charge. As is means the seller is not offering a warranty for future repairs. It means if the transmission fails 6 months from now, that's his problem. However, as is does not protect you from fraud. If you make a specific representation, like no mechanical issues, and that representation is false, and you knew it was false, that is fraud. Fraud vitiates a contract. That means your little as is paper isn't worth the ink you used to scribble it. Vance's mouth opened, then closed. He looked like a fish that had just realized the water was gone. Now, I continued, the question is, did you know, Mr. Henderson, you took the car to a mechanic? Yes, Your Honor. The tow truck took it straight to a shop. Do you have the report? Yes. Henderson handed another paper to Bird. I reviewed the mechanic's report. It was devastating. Blown head gasket, cracked radiator, evidence of stop leak additive in the coolant system. I paused. Stop leak. That was the smoking gun. Mr. Henderson, I said, my voice calm but dangerous. Do you know what stop leak is? The mechanic explained it to me. It's like a goop you put in to plug holes temporarily. Exactly, I said. It's a Band-Aid on a bullet wound. It's designed to hold a car together just long enough to sell it to an unsuspecting sucker. I turned slowly to Mr. Vance. He was starting to sweat now. The arrogance was melting away, replaced by the realization that he had walked into a trap of his own making. Mr. Vance, I said, holding up the report. The mechanic found stop leak in the radiator. Who put it there? I don't know. Maybe my aunt did. Your aunt? The lady driver? I raised an eyebrow. You expect me to believe your aunt, who supposedly kept this car in dream condition, was pouring industrial sealant into the radiator? Maybe. I don't know what she did. You're a liar, Mr. Vance, I said flatly. And you're not even a good one. A good liar keeps their story simple. You're flailing. You bought a lemon, you patched it up with $5 worth of goop, and you dumped it on Mr. Henderson because you wanted to make a quick buck. You didn't care if he got stranded on the highway. You didn't care if he lost his hard-earned money. You only cared about yourself. Vance bristled. You can't prove I put that stuff in there. It could have been the guy before me. You just said you bought it from your aunt. Now it's the guy before me? Which is it, Mr. Vance? Is your aunt the guy? You meant nothing because you are making it up as you go along. Listen to me. In a civil court, I decide based on a preponderance of the evidence. That means, is it more likely than not that you are responsible? I have an ad written by you claiming perfection. I have a car that died in 20 minutes. I have a mechanic's report showing a deliberate attempt to conceal damage. And I have you changing your story every 30 seconds. I lean back. I don't need a confession, Mr. Vance. Your behavior is a confession. But I'm not done yet. I want to see the text messages. What text messages? Vance asked, looking panicked. Mr. Henderson said he texted you. You said you didn't answer. I want to see what he wrote. I motioned to Henderson. Do you have your phone? Yes, Judge. Bird, bring me the phone. I took the phone. I scrolled to the date of the sale. I read the texts. Hey, the car is overheating. It's smoking. Please pick up. I'm stranded. And then I saw something interesting. A little bubble indicating a read receipt. Mr. Vance, I said, staring at the screen. You have read receipts turned on? I don't know. Well, Mr. Henderson's phone says you read these messages at 4:15 p.m. on the day of the sale. That was 15 minutes after he left your house. You read them and you ignored them. I was busy. You weren't busy. You were hiding. You knew exactly what was happening because you knew exactly what you sold him. If you were an honest seller who really thought the car was perfect, your reaction would have been shock. You would have said, oh my God, what happened? Bring it back. Let me look at it. Instead, you went dark. That is consciousness of guilt. I handed the phone back to Bird. Mr. Vance, you are going to lose this case. The only question now is how much it's going to cost you. Mr. Henderson, you paid $4,500. Where is the car now? It's still at the shop, Judge. The mechanic said the engine is toast. It needs a whole new engine. That costs more than the car is worth. So the car is scrap, I concluded. Yes, Your Honor, Mr. Vance, I said. You sold him a piece of junk. You owe him his money back. But I spent the money, Vance whined. I have bills too. I don't care if you spent it on lottery tickets and gummy bears, I shot back. That is not my problem. You took money under false pretenses. You are going to give it back. This is unfair. He drove it. He probably raced it. Don't be ridiculous. You don't blow a head gasket racing a 2012 sedan for 10 minutes unless the gasket was already rotting. You are trying to pee on my leg and tell me it's raining, and I am not buying it. Now, Mr. Henderson, you also mentioned the towing fees. Yes, Judge, $200 for the tow and $300 for the diagnostic. Do you have receipts? Yes, right here. I looked at the receipts. They were legitimate. I looked back at Vance. He was slumping in his chair, defeated but still looking resentful. He didn't look sorry. He looked sorry he got caught. That's a distinction I see every day. Mr. Vance, stand up, I commanded. He dragged himself to his feet. You came into my courtroom thinking you could bully this young man with a piece of paper that says, as is. You thought you were clever. You thought the law was a technicality that you could exploit. But the law is based on fairness and truth. You have neither. You are a scam artist. And today, the scam ends. I checked my notes one last time to ensure I hadn't missed anything. The evidence was overwhelming. The ad, the immediate breakdown, the stop leak, the ghosting. It was a textbook case of fraud. Judgment for the plaintiff, I announced firmly, $4,500. That covers the car, the tow, and the diagnostic. Mr. Henderson, you will sign the title back over to Mr. Vance. Mr. Vance, you can go pick up your scrap metal from the mechanic and do whatever you want with it. Maybe you can sell it to your aunt. I banged the gavel. We're done. But Judge Vance started. I said, we're done. I barked. Step out. I watched as they gathered their things. Henderson looked relieved, a weight lifted off his shoulders. Vance looked furious, muttering under his breath as he shoved his hands back into his pockets. "And take your hands out of your pockets on the way out," I yelled after him. He yanked his hands out as he pushed through the swinging doors. I sat back for a moment, letting the silence return to the room. Another liar exposed, another victim made whole. It wasn't about the car, really. It never is. It's about accountability. People think they can treat others like dirt just to make a quick buck. Not in my house. Next case, I said to Bird. But as Bird was preparing to call the next docket, I noticed something. Mr. Vance had left his as-is bill of sale on the defendant's podium. It was just a crumpled piece of trash now. I shook my head. Some people never learn. They think the world owes them a living. They think intelligence is the ability to trick someone else. Real intelligence is knowing right from wrong. And Mr. Vance was a fool. The bailiff brought me the next file. I opened it. A dispute between roommates over unpaid rent and a damaged sofa. I sighed. The unending parade of human folly continues. But for now, justice had been served on 4 wheels. I looked at the clock. Still time before lunch. Who's next, Bird? Parties are entering now, Judge. Case 483, Smith versus Jones. I straightened my robe. Let's get to it. I took a sip of water, letting the cool liquid wash away the bad taste of Mr. Vance's lies. The bailiff, Bird, placed the next file on my desk. Smith versus Jones. I glanced at the summary. Unpaid loan. Car dispute. Emotional distress. I sighed. Emotional distress. In my courtroom, that usually means I'm mad because I was stupid. People think feelings are currency. They aren't. Facts are currency. Parties, step up, Bird announced. 2 people walked in. On the plaintiff's side, a young woman, Miss Smith. She was dressed in a suit that was slightly too large for her, trying to look professional. Her hair was pulled back tight. She looked angry. On the defendant's side, Mr. Jones. He was older, maybe 40, leather jacket, slicked back hair, chewing gum. "Spit the gum out," I said immediately, before he even reached the podium. Jones looked startled. "What?" "The gum. Out. Now. There is no trash can. Stick it in your pocket or swallow it. I don't care. But don't chew in my courtroom." He grimaced, took the gum out, and shoved it into his jacket pocket. Disgusting. But at least he was listening. "Miss Smith," I started opening the file. "You are suing Mr. Jones, who is your what?" "He was my fiancé, Your Honor," she said, her voice trembling slightly. "Fiancé. Okay. You are suing him for $7,000. You claim he sold you a car that was a total lemon and then refused to return your money when it broke down. Is that the gist of it?" "Yes, Judge, but it's worse than that. Stop." I raised a hand. "I don't need worse yet. I need the basics. When did you meet Mr. Jones?" 2 years ago. "And when did you buy this car?" 6 months ago. March 12th? "And what kind of car was it?" "A 2016 Land Rover. He said it was his pride and joy." I looked over my glasses at Mr. Jones. He was leaning on the podium, looking bored. "Mr. Jones, is this your business? Do you sell cars?" "Nah," Jones said. "I'm a contractor. I just like cars. I fix them up sometimes." "You fix them up," I repeated. "Are you a certified mechanic?" "I know my way around a wrench, Judge. I've been working on cars since I was 12. "That is not what I asked you. I asked if you are a certified mechanic. Yes or no?" "No." "But I know what I'm doing." "We'll see about that," I said. I turned back to the plaintiff. "So, he sells you this Land Rover. How much?" "He told me he'd give me a family discount because we were getting married. He sold it to me for $12,000. I gave him $7,000 down, and I was supposed to pay the rest over the next year." $7,000 cash? "Yes. I pulled it out of my savings. I have the bank statement." "Hand it to Bird." She passed a document to the bailiff, who brought it to me. I glanced at it. A withdrawal of $7,000 on March 11th. "Okay, so you hand him the cash. Did you get a receipt? No, Your Honor. I trusted him. We were living together. I shook my head. Miss Smith, let me tell you something about love. Love fades. Dumb is forever. You gave a man $7,000 cash without a receipt because he gave you a ring? I know, Judge. I know now. Mr. Jones, I turned to him. Do you agree she gave you $7,000? She gave me $5, Jones said instantly. I paused. $5? She just showed me a withdrawal for $7. She might have pulled out $7, but she only gave me $5. Maybe she bought shoes with the other $2. I don't know. I narrowed my eyes. Mr. Jones, you look like a man who plays angles. You're telling me your fiancée, the woman you intended to marry, handed you cash and you didn't count it or write it down? We were in love, Judge. We didn't do paperwork. Right. So, Miss Smith, you paid him. You took the car. What happened? It was great for about 2 weeks, she said. Then the dashboard lit up like a Christmas tree. Check engine, oil pressure, everything. I told him about it. He said, don't worry, babe. It's just a sensor glitch. Land Rovers are finicky. And you believed him? He's the one who fixed it up. He told me he rebuilt the engine himself. I looked at Jones. Did you rebuild the engine? I did some work on it, Jones said evasively. Changed the oil. New spark plugs. Maybe a gasket or 2. A gasket or 2? That's like being a little bit pregnant. Either you rebuilt the engine or you didn't. Did you take the engine apart? No. I just freshened it up. I mocked, like a salad. I turned back to Miss Smith. So the lights come on. Then what? Then it stopped shifting gears. I was on the freeway trying to merge, and the car wouldn't go past second gear. The RPMs were screaming. I was terrified. I barely made it to the shoulder. I called him. He came and picked me up with his truck and towed the Land Rover back to our house. And then he said it was the transmission. He said it would cost $4,000 to fix, but since he loved me, he'd do it for cost. He asked me for another $1,000 for parts. Did you give it to him? Yes. I dropped my pen on the desk. It made a sharp clack. Miss Smith, you gave him $7,000. The car broke in 2 weeks. And you gave him another $1,000? He said he could fix it. He said without the money for parts, the car was useless. So now we are at $8,000, I calculated. Did he fix it? No. The car sat in the driveway on blocks for 3 months. Every time I asked him about it, he got angry. He said I was nagging him. He said I didn't appreciate how hard he worked. Then, in July, we broke up. Why did you break up? Because I found out he was seeing his ex-wife again. Of course he was, I muttered. Mr. Jones, you seem like a real catch. So, the relationship ends. What happens to the car? I told her to take it, Jones said, shrugging. I told her, get your junk off my driveway. But she didn't have the money to tow it, and she didn't have a place to put it. So I told her I'd charge her storage fees. Storage fees? I looked at him, incredulous. You sold her a car that didn't work, took an extra $1,000 to fix it, didn't fix it, and then charged her storage to keep it on the driveway of the house where she was living? It's my house, Judge. My name is on the deed. Once she moved out, she was trespassing, and so was her car. You are a charmer, aren't you? I said. Miss Smith, did you get the car? No, Judge. That's why I'm here. One day I came back to get my clothes, and the car was gone. I asked him where it was. He said he sold it. The courtroom went silent. I felt that familiar tightness in my jaw. This wasn't just a dispute. This was theft. Mr. Jones, I said, my voice dropping an octave, you sold the car? She owed me money, Jones protested. She still owed me $5,000 on the original price, plus the storage. I exercised my right to repossess the collateral. Repossess? I laughed a short, sharp bark. You aren't a bank. You don't have a lien. Did you have a contract stating you had a security interest in the vehicle? We had a verbal agreement. A verbal agreement is worth the paper it's written on, which is nothing. You cannot repossess a car you sold to someone just because they owe you money, unless you have a perfected security interest filed with the state. Did you file a lien with the DMV? No, I told you, I ain't a business. Exactly. You are not a business. You are just a guy who stole his ex-fiance's car. So you sold it. How much did you get for it? I sold it for scrap. Got $500. $500, I repeated slowly. Miss Smith, do you have proof of the car's value? Yes, Judge. Before I bought it, he showed me a listing for a similar one going for $14,000, and I have the Kelly Blue Book value here. In good condition, it's worth $13,000. But it wasn't in good condition, was it? I countered. It had a blown transmission and a freshened-up engine. That's because he broke it, she cried. Or he sold it broken. When I bought it, he said it was perfect. Mr. Jones, I said, leaning forward. You admitted you sold it for scrap. That means you destroyed the evidence. You took the car, which was the subject of this dispute, and you disposed of it so no one could see what was really wrong with it. That is spoliation of evidence. I was cleaning up my yard. The neighbors were complaining. I don't care about your neighbors. I care about the fact that you took $8,000 from this woman and left her with nothing, not even a hubcap. I looked at Miss Smith. Did you ever see the title? He showed it to me when I gave him the cash, but he said he'd hold on to it until I paid it off. He kept it in his safe. So the car was never registered in your name? No, Judge. Mr. Jones, whose name was on the title when you sold it for scrap? Mine, he said smugly. It was my car. I never signed it over. So legally, I can do whatever I want with it. He crossed his arms, looking very pleased with himself. He thought he had found the loophole. He thought that because the paperwork was in his name, he was untouchable. I took off my glasses. I rubbed the bridge of my nose. This is the moment I live for. The moment when the arrogant realize they have stepped onto a landmine. Mr. Jones, I said softly, you just admitted to a crime. Actually, several crimes. His smirk faltered. What? If the car was yours, and you took money from her for it, but never intended to give her the title until she paid a balance that you arbitrarily decided on, you were acting as an unlicensed lender. But let's put that aside. You admitted she paid you at least $5,000, though I believe her that it was $7,000 plus another $1,000 for repairs. That is equity. She had equity in that vehicle. I put my glasses back on. By selling that car and keeping the proceeds, however small, you committed conversion. You took her property, her equity, and converted it to your own use. And because you never transferred the title, you are now claiming it was never a sale? Fine. If it was never a sale, then the money she gave you was a loan or a deposit, which you are required to return if the deal falls through. Jones started to sweat. But she drove it. She put miles on it. She drove it for 2 weeks. You want to charge her $8,000 for a 2-week rental of a broken Land Rover? That's $4,000 a week. Hertz doesn't charge that much for a Ferrari. She wrecked it. No, you sold her a wreck. You said you fixed the engine. A rebuilt engine does not blow up in 2 weeks unless the mechanic is incompetent or a crook. Which one are you, Mr. Jones? Are you stupid or are you a thief? He stammered. I ain't a thief. Then you must be incompetent. You touched that engine. You broke it. You took her money to fix the transmission, and you didn't fix it. That is theft by deception. You took the $1,000 for parts. Where are the receipts for the parts? I bought them cash from a buddy. Of course you did. Everything is cash. Everything is a buddy. There are no receipts in your world because receipts tell the truth, and you are allergic to the truth. I turned to Miss Smith. Miss Smith, you are young. You made a mistake trusting a man who wears a leather jacket in July and chews gum like a cow. But that doesn't mean you deserve to be robbed. Thank you, Judge. Don't thank me yet. I need to figure out the damages. You paid $7,000 down, $1,000 for repairs. That's $8,000 out of pocket. You are suing for $7,000? Yes, Judge. That's the max for small claims in my state, I thought. Here, the limit is $5,000. But wait, I looked at the file. We are in arbitration. The limit here is $5,000. Unless I paused. There was a countersuit in the file I hadn't opened yet. Mr. Jones, you countersued her? Yeah. Jones piped up, feeling a surge of hope. She damaged my driveway, oil stains everywhere, and emotional distress. She keyed my truck when she left. She keyed your truck? Yes. Big scratch down the side. Do you have a picture? No, I got it buffed out. You got it buffed out, I repeated flatly. So, no evidence. And the oil stains? From the car you worked on? The car that leaked because you didn't fix the gaskets? It's still her mess. It is your car. You just said so. You said the title was in your name. If it's your car, it's your oil, and it's your driveway. Case dismissed on the counterclaim. I slammed my hand on the desk. Now, back to the plaintiff. Mr. Jones, you have admitted to taking her money. You have admitted to keeping the car. You have admitted to selling the car. You have essentially admitted to defrauding this woman under the guise of a romantic relationship. I looked at Miss Smith. Miss Smith, do you have any text messages where he discusses the money? Yes, Your Honor. I have a text where I asked, when are you going to fix the car I gave you $8,000 for? And he replied, stop nagging me. I'll get to it. Show me. Bird brought the phone. I read the screen. It was there in black and white. He didn't deny the amount. He didn't say, you only gave me 6. He accepted the premise of the question. Mr. Jones, I said, holding up the phone, this is what we call an admission against interest. She states the amount $8,000. You do not correct her. You just tell her to shut up. That tells me she is telling the truth about the money and you are lying. I didn't read the text carefully. You read it well enough to reply, you're done, Mr. Jones. You are cooked. I started writing on my notepad. Judgment for the plaintiff in the amount of $5,000. That is the jurisdictional limit of this court. If I could give her more, I would. I am dismissing the counterclaim with prejudice, which means don't you dare try to bring this nonsense up again anywhere else. But Judge, I don't have $5,000, Jones whined. You have a truck, don't you? The one she supposedly keyed. Sell it. Or maybe ask your ex-wife for a loan. I don't care how you get it, but you will pay her. This is crazy. She drove the car. She drove a lemon that you pawned off on her. You used her as a piggy bank. You're a gigolo, Mr. Jones, and a bad one at that. I looked at Miss Smith. You get a better boyfriend. And next time, get a receipt. Even if you're marrying the Pope, get a receipt. Yes, Your Honor. Judgment for the plaintiff. $5,000. We're done. I banged the gavel hard. Parties are excused, Bird bellowed. I watched them walk out. Miss Smith held her head high, vindicated. Mr. Jones was red-faced, muttering to himself, probably trying to figure out how to spin this to his buddies so he didn't look like a loser. He wouldn't succeed. The courtroom doors swung shut. Unbelievable, I said to no one in particular. The audacity. They never learn, Judge Bird said. No, they don't. Is it lunchtime yet? One more, Judge, a quick one. I groaned. Fine. What is it? Dog bite case. Oh, wonderful. Bring them in. I adjusted my robe. The car cases were done for the day, but the parade of irresponsibility was never ending. I took a deep breath. Time to teach someone else a lesson.